On the bonds, some of your former colleagues on the bench said, why didn't the court go further? If this was held to be, if it was struck down.
Did some of my former colleagues on the bench with me say
No,
that?
no. I mean, former Supreme Court judges, not on the bench with you. Other judges who have been Supreme Court judges in the past argued that you could have gone further in terms of, then why didn't you try and crack down on those who had paid and so on, right? Like you must have seen that commentary. Do you feel that you could have done more than just saying electoral bonds can no longer be used?
Well, as you know, about the former colleagues bit,
yes,
I'll only ask some of them this question. What did you do when you were on the bench? All right, but let's leave it at that. On the other aspect, on what we could have done, the challenge before us was the constitutional validity of the electoral bond scheme, which was brought in by a parliamentary amendment. We struck down the amendment, right? We held that the amendment was unconstitutional, and we consequentially held that there should be a full disclosure of everyone who had contributed to the electoral bonds. And we said that this must be placed in the public realm. When the State Bank of India came back to us and said there were difficulties, we said, we are not accepting this. You have to make that disclosure. Now, having said that, that was all that was argued before us. Every bit of the case that was argued before the Constitution bench has been dealt with in the judgment of the Supreme Court. Namely, the challenge to the validity has been upheld. The scheme has been struck down on the ground that it allowed for anonymous political funding of political parties, which would be manifestly arbitrary. And therefore, the names of everybody who had contributed must be disclosed. And the tax exemptions which were granted to contributors would therefore stand nullified. The do further came in the form of another petition later.
Right.
When we struck down the scheme, that was all that was argued. And
that was not before you at all.
Absolutely. That came in later on.
Got it. Now, towards the end, though I have so much to ask you, but towards the end.
And should I also add something about, why we didn't do further?
Yeah.
That again, Barkha, constitutional adjudication is not a simple process. People contributed. In round 2, we had a petition which said that constitute an SIT, constitute a special investigation team, and criminally investigate every donor who had donated monies as part of the electoral bond scheme. We didn't accept that.
Because that's not fair, right? Because the person donating is doing it thinking it's lawful.
Barkha, it's a very important point that you've made.
Yeah.
You've made a very, very important point. There are 2 points, which weighed with the court, which the order of the court speaks. The first, constituting a SIT is an exception to following the normal processes of the criminal law. Normally, anybody who feels that, an offense has been committed has remedies. You lodge an FIR. If an FIR is not registered, there are remedies under the law, so on and so forth. Going to the Supreme Court directly and asking for the constitution of the SIT is to obviate complying with the normal processes of the criminal law, which the court should not allow as a matter of first option. It's done in very, very rare cases. Second, another important thing is what you said, which is that, we struck down the scheme. We denied the tax exemptions. We asked for disclosure of information, let the people know who had contributed. The second point is that there was no challenge per se to corporate funding of political parties, which has been part of our polity for almost 60 or 70 years. There was no challenge to that even today of corporate funding per se. In fact, one of the arguments in the court was that nobody contributes merely out of altruistic motives.
Of course.
Right? Even when you place money before God, the bhakt always accepts, feels that, I'll receive some blessings on a lighter way. But, interestingly, look at it this way. You have a law which is enacted by Parliament. We are a responsible republic. A 75-year-old republic. Parliament has enacted a law. People act in pursuance of the law, albeit business houses. But let's not be hypocritical. Business today is also the source of productive employment, generating revenues for the Union of India and for the entire nation. To what extent do you pursue this? do you pursue people who, acting on the strength of a law enacted by Parliament, have contributed? Would that impinge upon the faith which people have in the political system, in the maturity of our system? So when you take decisions as courts, these are not simple decisions. Have an SIT, don't have an SIT. But obviously, these are factors which weigh in the balance when you take constitutional decisions.
Absolutely.